Hello everyone, welcome to today's news charter. Let's begin with the prelims practice question of the day. It takes in even such basic questions. The statement is, which among the below mentioned does not come under the Article 21? Article 21 is about right to life and personal liberty. But there are a lot of other rights which are implicitly mentioned in Article 21, even though explicitly they have not been mentioned in the Constitution of India. So the Supreme Court in multiple different scenarios have provided and included several different rights as implicit rights under the Article 21. So four rights are provided here. It is very difficult to remember each and every right and each and every judgment. It is impossible. But with your common sense, you can easily answer such questions. Four rights are provided: right to sleep, right against sexual harassment at workplace, right to reputation, and right to speech. So you can, if you have studied fundamental rights very clearly in a detailed way, not just to remember all the fundamental rights, and if you have read it with proper understanding, you will know that right to speech is mentioned in Article 19. And when one right is mentioned in one article, there is no use for it to be mentioned under another article. So right to speech does not come under Article 21. Let's start with the topic. Juvenile Justice Amendment Act 2021. Juvenile Justice Amendment Act, prevention of sexual harassment at workplace, and POCSO, that is Protection of Children from Sexual Offences Act. These acts are extremely important. Now, from society's point of view, that is under paper 1 of GS, you need to know each and everything. So in the recent times, what happened is the Kerala High Court held that in one of the judgment held that a child that is charged under the POCSO, if a child, that is a person who is below 18 years of age, has been charged under POCSO, we will be prosecuting that child according to the Juvenile Justice Act and not the Prevention of Children from Sexual Offences. POCSO was created so that adults who violate the children's rights can be prosecuted, not against children. So if a child is doing any kind of act, any kind of cognizable act, it comes under the Juvenile Justice Act. So this is the basic judgment. If in case you get a question about it in prelims, you should be having good clarity about it. The crimes that is mentioned under other offenses against children. So this is these two provisions here I'm discussing about the Juvenile Justice Amendment Act of 2021. According to Juvenile Justice Amendment Act, two important provisions were included. These are all the two important provisions which you need to know. Juvenile Justice Act was passed in the year 2015. The salient features of Juvenile Justice Act is provided here, three important provisions. Here we are going to talk about the two important amendments that were made in the year 2021. So in 2021, the first major amendment is that in the 2015 Act, there was a specific category called as other offenses against children. And for this other offenses against children, they were subjected to 3 to 7 years of imprisonment. But in the Amendment Act, they have made it as non-cognizable. That is, if anyone is engaged in any offenses that is provided under the topic other offenses against children, such offenses will be non-cognizable. That means you cannot just like that arrest anyone. You will have to arrest the person only after getting a judicial warrant. So without warrant, you cannot arrest. This is to prevent misuse of this act. Second, about adoption, it has given a very important and a very good change, that is, district magistrate will be having the authority to sign the adoption orders. Earlier, according to the Juvenile Justice Act, it should be done by the court. So it takes a lot of time. It takes huge amount of delay. So they have done it in this manner that now the district magistrate himself can sign the order, and once he signs the order, the adoption can be processed. So what are the major important provisions that were mentioned in 2015 Act? First, the Act offers provisions to allow trial of juveniles in the age group of 16 to 18. Earlier, this was a very contentious provision because there were a lot of people who told that people who come under 16 to 18 years are children, so they should be considered according to children's provision. And there were a lot of other people who told that from 16 to 18, you cannot consider them as children. You have to consider them as adults or adolescents. So in this act, they mentioned it clearly that juveniles in the age group of 16 to 18 will be prosecuted under the Juvenile Justice Act only, not under other laws. They created the Central Adoption Resource Authority, the CARA, which will be a statutory authority and it will take care of adoption related issues. All child care institutions in the country should be registered under the Juvenile Justice Act. So these are the significant provisions. Living well is a very important topic from the mains point of view. It can be asked in GS1, it can be asked in GS4 also, because one thing it is about the passive euthanasia. So it comes under society. And second, it can be asked from ethical point of view because a lot of people oppose living well by telling that we as human beings do not have the right to take our own life. So we will discuss about it now. What exactly is a living will? A living will is a legal document prepared in advance. A legal document prepared in advance by a person about how he would like his life to end when he is in a situation where he is living only with medical support, only with the support of the medical instruments. For example, if a person is terminally ill, he is not in a position to walk, he is not in a position to do anything, only with medical help he is surviving. In such cases, how he would like his life to be, because if you even if you take from ethical point of view, that is a place where that person has lost his self respect himself. So in such cases, how to proceed? Or if a person has gone to coma, so in such case, he is not in a position to decide about anything. So what to be done in such cases? So that is called as the living will. So it is prepared in advance, detailing the preferences for medical care for the termination of medical support. So if a person is living only with medical support, if the medical support is removed, he will die. If a person is in that kind of a situation, what to be done? So that is mentioned in the living will. A person can mention about it in his will that if in any case I go to such a situation, this is how I like my life to end. So one very important and significant judgment in this context is the Common Cause versus Union of India in 2018. So there are two kinds of euthanasia. Euthanasia is making one to die, right? When he or she is in a grave situation, making him or her to end the life. That is euthanasia. Active euthanasia is when you give a foreign substance such as an injection or something and kill that person. Passive euthanasia is just you remove the medical or life support. So in Common Cause versus Union of India, the Supreme Court told that every person has a right to die with dignity. Be very careful here. The Supreme Court did not tell that you have the right to die. The Supreme Court told that you have the right to die with dignity. So when a person want to die, he should be in a position to die with dignity. So he should not be in a vegetative state, not able to do anything and then die. So this was mentioned in Common Cause versus Union of India. And they also told that it comes under Article 21, that is right to life. So passive euthanasia is allowed in India, but do we have any law for that? We do not have any law for that until now. So a living will should be signed by the person making the will in the presence of two witnesses and judicial magistrate of first class. A person can make a living will. It should be made along with two witnesses and in front of a judicial magistrate. So recently in 2023, another case happened, and the Supreme Court told that we do not need a judicial magistrate. We do not need a judicial magistrate. An attestation by a notary or a gazetted officer would be sufficient. Judicial magistrate is not required anymore. So two-person who are witnesses, and then the living will should be made by attested by a notary or gazetted officer. That's all. The document will also be a part of National Health Digital Record. So earlier we need to carry it personally. Now we have National Health Digital Record. Everything is digital. You can directly upload the document into the National Health Digital Record. Any hospital anywhere in the country will be able to access it. So this is all about living will. Kerala moves a petition against the president. So recently what happened? The Kerala government has filed a case against the president in the Supreme Court by telling that the president has rejected four laws which were passed by the Kerala Assembly. Laws were passed by the Kerala Assembly and then presented to the governor. The governor reserved it to the president and the president rejected it. President will not reject it on her own. It will be based on the recommendations of the Council of Ministers. It will be based on the aid and advice of the Council of Ministers. So when someone files a case against the president, they are indirectly accusing the Council of Ministers by guiding the president in a particular way. So from examination point of view, you need to know about certain important articles. One very important article here is Article 361 of the Constitution. It says the president or the governor shall not be answerable to any activities performed by them with the power and duty of his or her office. If a president or a governor do anything in their power, that will not be questionable in the court. So this is to maintain the status of the president or the governor. But the Supreme Court can tell whether it is right or wrong. At least that much the Supreme Court can tell. So based on what argument the state has filed the case? The state told that it is against Article 14, it is against Article 21. Why is it against Article 14? Because when the acts are passed by the state and it is submitted to the president or the governor, and if they are rejecting it, whereas for other states they are not doing it, in that cases it is against the right to equality. Against Article 21, because legislations are extremely important for the survival of the people. If you do not accept the registrations, accept the laws and legislations, that means you are not taking into consideration the well-being of the people of the state. So it is against Article 21. So this is what the state has been telling. But it is for the Supreme Court to decide. We have to wait until that. But one very important article, apart from the previous article, what we need to know is Article 200. Article 200 talks about the governor's power when it comes to assent to the bills. The governor shall assent, shall either give assent to the bill or withhold assent or reserve the bill for the consideration of the president. So three options are provided here. Either he can give assent to the bill, or he can reject the bill, or he can reserve the bill to the president. In case he gives assent, it becomes a law. If he sends the bill back to the legislature, and if the legislature passes the bill again, in such case, the governor has no other way. He has to give assent. There is no other option. So this is the reason the governors, when they do not want a law to become when they do not want a bill to become a law, what they do is they reserve it for presidential assent. But according to the constitution, it is clearly mentioned the governor can present a bill to the president or reserve the bill to a president only if the bill is trying to take away the powers of High Court. In other cases, We don't know whether they can do it or not. So the constitution is not clear about it yet. So it is for the Supreme Court to give us a solution on this. So you need to be very careful about this act, this case. You need to follow it properly. From Main's point of view, anything that affects the fundamental rights of the people, it is important for the examination. About Internet Freedom of India, it has been told that for the last 5 years, India has been the worst protector of internet freedom, because 60% of all internet blackouts in all over the world happened in India in the last 5 years. One important case which you need to know from the examination point of view is Anuradha Bhasin versus Union of India, in which the Supreme Court told that internet shutdowns completely is against the fundamental rights. Here you are taking away the right to equality, you are taking away the right to freedom of speech and expression, and then you are taking away the right to life and personal liberty. So they have told, if there is a requirement in such case, you can remove the access, but it should be proportional. It should not be disproportional in nature. Prelims point of view, one thing which you need to know, because in the recent times, India's foreign portfolio investment has been increasing to a greater extent. So the difference between FPI and FDI. Very simple. If it is a foreign direct investment, a foreign investor will come and take stakes in the companies that are operating from India. They will directly invest in the company. They will play the role of a director or a board member. Whereas if it is a foreign portfolio investment, it will be on stocks and bonds. They will just purchase stocks and bonds. They will not be worried about the management of the company. They will not be worried about the day-to-day working of the company. That's the difference between FDI and FPI. So from a long-term point of view, FDI is more important than FPI, because when someone is investing in the country just on stocks and bonds, whenever there is a slightest problem, they will just sell away all the things and go out of your country. So these are all the important points you need to note down and study from today's newspaper. Study well, all the best. Let's meet tomorrow.